Hi, everybody. It's Lindsay and Sam from Brittany Law Army. We are here tonight to discuss some questions you've thrown at us on Twitter about various topics that are trending within the Free Britney movement. We both have different opinions, and you should construe what we have to say to you as opinion and nothing else. We are both practicing attorneys, but this is not a legal advice video blog. This is just us talking about how we feel based on our experiences and practicing law. Ultimately speaking, there have been several topics, so we're going to kind of flip them back and forth and just talk them out. Um, Obviously, feel free to reach out if you have any further questions on our Twitter page. So I'm going to start with the Sam Ingham endorsement of Vivian Thurine on LinkedIn. I give it a huge thumbs down. I understand that attorneys have professional relationships and we have friendships. Most of those friendships are formed when we go to law school and we, meet a lot of people that are going to be practicing in the same physical area as us. Sam and I went to law school together. We have several friends who don't practice the same type of law as us or stand on the same side of the V as us. We're plaintiffs' attorneys. Some of the people we went to school with became defense attorneys, and that's fine. You have to have them on both sides. However, with that being said, unless Sam Ingham and Vivian Thurine are buddies, I don't think it's appropriate that he endorsed her on LinkedIn. Even if that endorsement was pre-conservatorship, so pre-2008, it's one of the first things that I would have done once this battle began is to make sure that, the perception that I give to the public and hold myself to behind closed doors is that I'm 100% on board with my client, supporting her cause in this case. And I feel like endorsing your opponent is not on board with that message. I also just don't actually appreciate Vivian Thurine as an attorney. I don't think that what she's doing as it relates to this conservatorship is right. I think that if I had been in her position and thought Brittany needed a conservatorship, which I don't, but if I had thought that back in 2008, surely at this point, you would know she didn't need one. She doesn't want one. She's made that clear. So why are you supporting a client who's persisting in violating her rights? I don't understand that. You're not getting my endorsement, period.
And I just think that this LinkedIn endorsement is nothing to lose sleep over. It's laughable. If you have a LinkedIn, you know that you get endorsements for um, obscure things from obscure people that you probably haven't talked to in a number of years. I don't think that something that is done on LinkedIn or on social media really equates to any sort of illicit relationship or undue influence from opposing counsel. I just think it's laughable and something to try not to overanalyze.
So again, I give it a thumbs down. I would overanalyze it. I would look at that as an endorsement of Vivian as a person and as a professional. And considering that I could not endorse her right now based on her involvement in this case and the length of time that she's been involved in this case, I just think that it's poor form for Sam Ingham to have endorsed her and or to continue to have his endorsement on her LinkedIn page. But I do understand what Sam's saying. I mean, it is difficult. This is a job for us, and it's important to be professional. It's important to be cordial. It's important to recognize other attorneys' strengths particularly if you're trying to beat them. I just don't think you have to do it on LinkedIn, and I just don't think that I would. But I totally get it. If there was a non-professional friendship outside of this case. But if that was the case, then, I would have so many more questions about, oh, if you're friends with Vivian, then what, have you guys both been riding this boat together the whole time? But we won't get into that. Basically, I'm thumbs down on that endorsement. So,
I'm just very indifferent. So our next topic, which is fine apparently, I wrote that note, is the filing of a fraud claim filing a fraud claim to the FBI. I think some people mentioned money laundering. I think we're just not there yet. We, I guess in theory, could, but in general, I think it's important to realize how complex cases play out. So Linsey and I often encounter clients who have multiple claims against multiple individuals or multiple entities, and we try to take one at a time. You don't want to throw all your arrows out at once. You need to be very methodical about how you go about litigating your case or cases and all the issues. So I think the first step is to deal with the conservatorship, with the accounting and the conservatorship, get the evidence there, and then hopefully the people who have Brittany's best interest, or her court-appointed attorney right now, Sam Ingham, or the attorneys that she hires once she is out of the conservatorship, they take the evidence that is compiled through these hearings and the Los Angeles probate court, and flush it out and pursue wherever that leads. Just follow the money. But at this stage, the evidence isn't quite there, and it's not right at the moment.
So I completely agree with everything that you said. I would say, that this question came about because of some excellent research that Surprise Witness did into Lou Taylor's company and the offloading of assets to the tune of, $500+ million into a offshore Panama account. It's not illegal to have offshore accounts. That's how shady people stay rich and shady. And ultimately speaking, before you want to pull the trigger and accuse a party of fraud, you need to make sure that you have the documents that are necessary to back that up. We can't have those documents unless a forensics accounting is done and those documents are made public. That's what we're hoping is going to happen in the next couple months. Another thing with filing a fraud claim on behalf of someone else is that it's very difficult when you yourself have not been individually injured, either actually injured or your property stolen, embezzled, etc. Do I think that Lou Taylor is committing fraud? Yeah, I really do think that. But that's a thought. That's based off of the evidence that exists right now. There's a rule of completeness that's important, that you get all of the information you can get before you push forward. Another thing to remember is, again, when you're thinking about it from a personal injury perspective, was I myself injured by this fraud? Obviously, no. Lou Taylor doesn't manage any of my money, and nor would she ever manage any of my money. But it's for Brittany. This is her estate, and it's for her to bring these claims, and that's the biggest travesty that exists as a result of this conservatorship, and I think something that Sam and I both felt very strongly about, was that she has been stripped of the ability to hire people to work for her interests and her interests alone. She has been stripped of the ability to make decisions that she should be able to make. And in doing so, she's been stripped of the ability to bring a fraud claim if she believes that fraud is occurring as it relates to the management of her assets. She can't do that by herself. And that's what we want. We want to see her get out of this conservatorship so she can do that, so she can sue these people that have injured her. And so, basically, we would like to see all of these individuals meet the karma they deserve. It's all about timing. And right now is just not the right time to do it. So you can absolutely do it. You can go to Google, FBI, find a local field office, and file a claim. Is it likely to proceed forward? No, I don't think so. So that's my take on it. Anything else to add about that?
Nope.
Okay, so the next topic you guys didn't really ask us about, but as an added bonus, we're going to discuss it because I have been talking about it nonstop for the last, 6 days. Matt Gaetz and Jim Jordan's endorsement of the Free Britney movement and the messaging that they're putting out as it relates to Jerry Nadler, the Judicial Committee, having the ability and authority to do something about Britney's situation. Let me be very clear. I am very glad that they are bringing publicity to the movement, that they are standing behind the national momentum that forced Vivian Thurine and Jamie Spears to go on a national campaign supporting the conservatorship. They're standing on all of your coattails saying, oh yeah, let's free Britney. And you know who can do something about that? Jerry Nadler. I'm here to tell you that he can't. Probate, conservatorships, guardianships, these are issues that are specifically reserved for state law. I mean, they were reserved at the founding of this country as a state law issue. Federal courts have little to no jurisdiction over issues that deal with conservatorships. And as a result of that, the federal judiciary committee that Jerry Nadler chairs could have little to no impact at all on Britney's situation. I don't even think that they could investigate the situation, as again, it's completely outside the scope of their authority to do so. So what I think is happening is Matt Gaetz and Jim Jordan are trying to sow seeds of divisiveness within the Democratic political party and many of Jerry Nadler's constituents by saying that Jerry Nadler can do something about it, full well knowing that he can't. You know who can do something about it are the state legislatures in California, are the state representatives. And you know who is doing something about it are those same state representatives. They have started making movements in response to Britney Spears' situation that will hopefully impact conservatorship law in California in the most positive way possible so that nobody ever has to suffer the way that she has suffered again. I want to also be very clear that I do not support Matt Gaetz or Jim Jordan as congressmen at all. I think the policies and platforms that they stand for are ludicrous and heinous. I think that the people they associate with, for the most part, are disturbing. I'm not a fan of theirs. I'm not going to speak for Sam, but as his friend, I can tell you he's not their fan either. Um, we are very glad that they're bringing light in a more public way and reaching a broader audience about what's happening to Britney Spears, because that's what's making a difference is everybody talking about it, putting it out there, keeping it at the forefront, keeping it trending. It's important for sentiment to stay pushing in the direction of getting her out of the conservatorship. But I'm not giving them credit as individuals in that they're doing this for her or for our country. I think that they're doing it for them and their party in order to try to pit us against Jerry Nadler and the Democrats in DC right now. They can't do anything about it. If you want to support somebody, support the California legislators who are doing something about it. Support the ones that are running with this as one of their platforms to reform this process in California, because that's how it gets done. It doesn't get done at the national level. And that's all I have to say about it.
Well, first of all, Lindsay's 100% correct. I am fiercely opposed to both Matt Gaetz and Jim Jordan. Not fans of either one of them. The other thing that Lindsay is correct about is basically everything she just said. That there is little to nothing that the Judiciary Committee could actually do to resolve Britney's specific case or any individual specific case. It's the province of the states, it's state law. Anything short of a constitutional amendment isn't going to cut it. And they know that. And all you have to do is look at the letter that they actually sent out. They're not asking, Matt Gaetz and Jim Jordan in their letter to Nadler did not ask for intervention in Britney's specific case or anyone's case. They want a broad investigation, look into the different state statutory schemes for conservatorships, or in some states, they're called guardianships. All 50 states have their own set of laws that define how this plays out. They just want to take a look at that. That's what the letter says. Let's take a look and publish a report. Well, a report isn't going to do anything for Britney or anyone else that is in a conservatorship that they should not be in. So
Yeah.
that's all I'm talking about.
I mean, so to answer your questions that never existed, we don't like those guys. And it's important that we definitely keep, pushing the message, but I'm not going to stand them. And I'm not going to act like they're saints for doing what they did, because they're not. They didn't do it for those reasons. If good comes out of it, then that's a happy consequence of poor strategy on their part. But just make sure that it doesn't divide, us as individuals and demanding things from DC that can't actually happen. So I think, Sam, you've got the last topic.
Sure. So the last topic is Ingham's objections to the 12th account, to the motion to seal the report from the 12th account. We recently put out on Twitter the proposed order. It is a proposed order because Ingham filed it with his signature without the judge's signature recently. But it's proposed, it's going to get granted. It's just, form. But I think some things have been taken out of context. We, in the tweet, when we posted Ingham's proposed order, we noted that Ingham withdrew his objections. His reasons for withdrawing those objections aren't quite clear. There was a motion to seal. That's a broad global term. There was a motion to seal, then there was an objection to the motion to seal. So Ingham broadly objected to the motion to seal. But his objections were specific objections. There were 8 that he said this information should be unredacted, but in the motion to seal, Jamie and his team want to redact this information. Post filing his objections, there was a meet and confer sometime, I think in November, maybe December, which is when the parties get together, the attorneys on both sides, they get together and they try to resolve their disputes over discovery, which the courts highly encourage. They want the parties to work things out among themselves. That happened, and all but one of the 8 issues were resolved. They were resolved to be unredacted. So there's one issue remaining. I'm not sure because I haven't been able to go back into the full record. I was kind of unplugged during November when the hearing occurred on this issue. So I don't know if they worked it out at the hearing and the judge told the parties, one of you all need to memorialize this, put it into an order and file it. And that's what we're seeing. But for the most part, it appears that Ingham was satisfied with the resolution he reached with Jamie's attorneys on his objections to the motion to seal and the redactions with the 12th County. I think it'll become more clear to us eventually once we have this hearing coming up on March 17th next week. We'll see more about how that played out and what information is going to be put into the public record as opposed to being filed with redactions and under seal.
Yeah, I totally agree. Basically, I think that the question is whether or not Ingham conceded when he withdrew his objections, or whether or not there was a compromise reached during the conversations that he would have had with Vivian Thoreen and her team. The meet
Right.
and confer that's required at the beginning, like Sam said, it's highly encouraged by the courts. In fact, we do it on a regular basis with opposing counsel. And then we file some sort of status conference memo that says what we discussed, what we agreed on, and then file an agreed order. In this case, they met and conferred. There was still one objection on the table. Just because that conference was over, it doesn't mean that Sam Ingham and Vivian Thoreen would not have been talking about it over the course of the next several months. They're both aware of what the law is. Sam would have known if this objection was likely to get granted. Vivian would have known if it was likely to get granted. And they would have made, compromises based off of that. Like maybe we won't redact all of this, but we'll redact part of it or whatever. Those are conversations that are had in private, subject to privilege. We won't know until the accounting paperwork comes out. And as a result of that, we can't really decide if it's a good thing or a bad thing at this point. And I think Sam's right. The hearing coming up, that's going to be very helpful to determine, what steps have been taken, who's going to be entitled to what. Hopefully, these questions will be answered at that point, and we'll know whether or not Sam Ingham, really got what he needed to get prior to withdrawing his objections. Well, I think that's all I have in me for today. Sam, is there anything that you want to add?
I'll just add that this is our first time trying to put together a video and just don't be too hard on us. We're
Yes,
gonna
be
figure
kind.
all this out one step at a time.
We're definitely putting ourselves out there, and we hope that you get something out of it. Bye.
All right. Peace out.